to the T-roh Show. Transmitting truth one week at a time.
Welcome to the 48th broadcast of the T-roh Show. It's your host, Keith. Stu.
Good afternoon.
All right, folks. Once again, we're going into someplace, going into the la-la land of America. That's what I call it. The an issue came up last week that I never thought of myself, because we all grew up with it, and we were raised with it, so we never even thought about it. And at least I didn't. I don't know if anybody else did, but it's just one of those things, little irritants, you know, that kind of hits you, but you're like, what? How did this happen? It's dealing with the contempt powers of a judiciary. They're saying that it came from the 1789 Judiciary Act and all this other stuff, which has already been debunked, that was never done. Even if those that believe the Constitution was ratified by real delegates, that we've covered in past broadcasts, that it still was not done, the 1789 Judiciary Act. So we started looking into contempt and saw some extremely amazing things about it, because actually contempt is a violation of a lot of things, a lot of laws, a lot of this, a lot of that the judges are using freely. And it's only because people have been raised with it. Well, that's why everybody goes in there all scared, because the judge can hold you in contempt and throw you in jail. Now, that's what you believe he can do. But because you believe that, then it makes it real. And because other people believe it, it's been widely accepted without any question until now.
Yeah, I mean, it's, as a kid, it's one of those things you see in the movies, right? And you get perpetually, it's perpetually pounded into your psyche that, hey, wait a second, there's contempt here. You got to show respect to that judge.
Right. And the funny thing about it is, I read a couple of articles on it, and in the articles they were talking about the Supreme Court, and we've shown in the past the Supreme Court's a private company. But the funny thing is, the Supreme Court's never used the powers of contempt at all, ever, in its whole existence. Gee, I wonder why. Is it because they never had to, or is it because they knew they couldn't? That's the whole thing. Those are just questions I've got. All right, so we're going to show you some of I've got a lot of these yellow highlighted. And these are just yellow highlights through a 30-page thing, because I know you guys didn't want to sit with me and listen to me reading a 30-page document. So aside from contemporary mid-20th century conflicts, can the contempt power be traced to a proper historical foundation? Or was the comment some time ago made by one student of the problem correct, that this criminal arbitrary power is less assailable than unquestioned historically, though it is foreign to the whole spirit of Anglo-American jurisprudence? So where did this come from? That was the whole thing. And why do they claim that it's inherent and all that kind of jazz? Well, come to find out, a lot of it came from the kings. The power of courts to punish contempts is one which wends historically back to the early days of England and the crown, a product of the days of kingly rule. It began as a natural vehicle for assuring the efficiency and dignity of and respect for governing sovereign. Viewed as a legal doctrine which was articulated and immersed in the common law, and is generally a product of Anglo-American society. That's what they call it here. However, Last I heard, folks, we don't have a king unless they're talking about what could be the king of Benevolence, or could it be that old monarch over there in Vatican City? Don't know. But it goes all the way back to the kings. And says, and the law of contempt is not the law of men, it is the law of kings. It is not law which representative legislators, responsibly reflecting the vox populi, originally wrote, but is rather evolved from the divine law of kings and its aspects of obedience, cooperation, and respect towards government bodies. Though it is not the only source of power, it is the seed from which the power grew. If later adopted and cultivated by men not adverse to its exercise, these latter institutions agreeably accepted it, less and adjuncts of the king than to protect their own dignity and supremacy. So this is how it works. Okay, you take Spain, for instance. See, a lot of people think Spain is a democratic society, which just absolutely is not. What it is it's run by a monarch, and that monarch has a government, and that monarch is an extension of the king's throne. That's how it is in Spain. That's how it was back in England. Still is today. Those representatives are not representing the people. They go, the representative so-and-so, representative so-and-so. That's not what they're doing. They're representing the king.
Right.
Which is just exactly opposite of what people believe.
Right, which is that intro there of that paragraph you just read. It is not the law of representative legislatures. What he's saying is representative of the people, true legislatures.
Right. It's just a representative of the king. So the idea that obedience to divine commands was good and disobedience sinful, because remember, the kings used to call themselves the Vicar of God, has been traced to the assertions of the early popes as well as the emperors. The king was called early in English history the Vicar of God.
Of course. Why not?
Yeah. So if you went against the king, you were going against God. That's how they believed way back when.
Well, that's how the authority people slanted it so that, the people would believe that.
Right. And they still believe that today, by the way. It's still that way in countries today.
Yeah. Whereas
that hasn't changed.
Yeah. Whereas, and we can pull this up if you think it's worthy, but within the law of nations, you read that, the sovereign is basically placed in that position by the people. Thus, the sovereign must act according to the people, and anything outside of that, they're subject to reprimand and or what happens. But that's
that's not true, Stu. They say they're the Vicar of God, so it must be right.
Right. Yeah.
I understand.
So there's been a slanting of the message.
Right. The contempt power is understandable when seen through the perspectives of its age of inception, an age of alleged divinely ordained monarchies, ruled by a king totally invested with all sovereign legal powers and accountable only to God. Isn't that amazing how one guy can claim that, but anybody else claims that? We can't do that. It's just amazing how they're able to pull that off. It says, under any circumstances, resistance to the king was a sin which would bring damnation. Well, that's amazing. That was a pretty powerful dude. Still is today. So it says, as society became more diverse and extensive, the English kings found it necessary to have their kingly governmental powers exercised by representatives. This is what we're talking about when they're representatives of the king. The courts then of early England acted for the king throughout the realm, and their exercise of contempt powers derived from the presumed contempt of the king's authority. Violation of their writ or disobedience to their officers violated the peace and flouted the king they represented. The contempt power of the equity courts had a similar origin. Now, last I heard, and especially the way the people say here, that their beloved, Constitution does not have kingly powers. That's not a monarch. At least I've heard that from some federal officers. No, that's not a monarch. It's a democracy. Well, then why does your judges have contempt powers if it's not a monarch?
Yeah, and how can you have the people, supposedly the rulers of the country, if someone can say it's time for the people to shut the hell up, it's time for the people to sit down, or they're going to get fined, tossed in jail, etc. It actually doesn't make any sense at all when you really think about it. Of course,
that's a trial without jury.
Mm-hmm.
He throws you in jail and fines you. That's a trial without anything. He's able to keep you in there as long as he wants. He can keep you in jail for contempt for as long as the man wants to do it, the way it is right now. But what were they in contempt of? Well, they're contempt of court. Well, okay, so the judge is saying that's his court or her court. This is my court. And we've always heard them say that over and over again. It's my court.
Not the people's.
Yeah, it's not the people's. So the very instance that the judge says this is my court, it's no longer a public court. And if it's no longer a public court, then you have a human rights violation because you're guaranteed a public trial. So,
ding, 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 ding.
Yeah, that's what I'm saying. This is some messed up stuff here. It says, under the Norman kings, an offender's personal property was forfeited to the king's mercy. Huh. So under American judges, an offender's personal property is forfeited to the judge's mercy. Later, this was changed to a fine, which in turn was later refined into a procedure whereby the offender was imprisoned until the fine was paid. This is akin to the current practice with contempt. For civil contempt, the offender is imprisoned until he purges his act of contempt. You got to go back and apologize to the court.
Right. So what do you got? You got a bunch of county fiefdoms.
Mm-hmm.
Quite literally.
Exactly. It says originally contempt of Congress was used merely to coerce cooperation, at which time the imprisonment ended. Huh.
Coerce. Nice word.
Yeah. Coerce cooperation. Okay. This is called pain compliance right here. Coerce cooperation. That's called pain compliance. Pain compliance is torture. So I'm going to put you through pain if you don't submit to my private court in violation of your human rights. I'm going to apply pain compliance on you if you do not submit your intangible property rights to things and submit to the jurisdiction submit to the violation of your human rights. That's what I'm trying to say here.
Right. So we're gonna traffic you into our little fiefdom.
Mm-hmm.
We're gonna violate your human rights, and then when you protest, we're gonna throw you in the slammer until you pay a significant amount of money to get out.
Right. Right. So for criminal contempt, the offender of today may be fined, imprisoned, or both, and non-conditionally. And the people today just accept that as if it's nothing. I mean, I'm just as guilty about that. I didn't even think about that.
Yep. I admitted it to you prior to the show.
Yeah. It's just,
it struck me quickly, first paragraph or so. And I was like, wow, fantastic. But up until then,
never even thought about it.
Yep. Gave it no thought whatsoever.
says, thus, from the earliest laws of the kingdom through the records of Curia Regis and Parliament, the yearbooks, and the first treatises on law, the development of contempt in the legal sense can be traced until the 14th century. The principles upon which punishment is inflicted to restrain a disobedience to the commands of the king and his courts, as well as other acts which tend to obstruct the course of justice, have become firmly established. It read that the contempt had been committed against us, us being the court and the king. Us being the court and the king, and its king. The court and its king. I'll say that one more time. Us being the court and its king. So, we went through a lot of this, and it says, by our Constitution, How many times have you heard that? By our Constitution. The king is the foundation of justice, and he delegates the power to the judges. Arraignment of the justice of the judges is arraigning the king's justice. It is an impeachment of his wisdom and the choice of his judges. It excites dissatisfaction with judicial determination and disposes the minds of the people to obey them. Indisposes the minds of the people to obey them. This is a most fatal obstruction of justice and calls for more immediate redress than any other. It goes on, folks, and it goes on. We've got some more yellow highlight here. Then Lawless, an attorney from Missouri, provoked Congress into initiating impeachment proceedings against Judge Peck for willful oppression. I wanted you to see that little term, willful oppression, because willful oppression and pain compliance are the same thing. That's an actual charge. Willful oppression. That charge has been removed from the books. No one really even knows that that exists. It says, one of the arguments made at these hearings was that the power of judicial contempt was not inherent, but a product of the common law. That would be English common law. Ergo, since Almond's case was not common law, it never had been officially published, never having been officially published, which means it was a private court, its effect was void. The judge claimed innocent and fair interpretation of the common law power of contempt of court, basing his conclusions upon the English decisions that preceded his. Yet the strong feelings about freedom of the press at the time of the Peck debates precipitated against this oppressive judicial power. This has been grabbed before. So what happens is the Masonic courts, they wait till the next generation, then they just proceed as if nothing happened. Just like I think Hillary did that. Hillary was going, for being president, but was hoping that this generation of voters forgot all about the 90s. And the fact that her husband was getting a Lewinsky in the office. They call it a Lewinsky now. I mean, it's pretty bad. It's your last name or your family name's associated with that, but everybody forgets all that. So that's what she was hoping too. And that they do the same thing over and over again. They wait just about 20 years and they know a next generation has come in, and that generation doesn't know anything about what happened in the past. So anything said about that individual coming from the early 80s, 70s, 80s, and 90s, that all just looks like slander. That's what that,
Right, and it's conveniently not included in school curriculums and things like that.
Right. They just kind of, brush it away. It says, however, the general powers of courts to punish for contempt was little questioned during these early days in the United States. In one reported case, Justice Field of the Supreme Court wrote, the power to punish for contempt is inherent in all courts. Its existence is essential to the preservation of order in judicial proceedings and to the due administration of justice. Oh, you mean the due administration of justice that benefits only a small group? Well, right. I understand that now.
In your fiefdom.
Yeah, in your fiefdom. It says the moment of a court, or the moment the courts of the United States were called into existence and invested with jurisdiction over any subject. Huh. Excuse me? Subject?
Wow. Wow. Wow.
They became possessed of this power, contempt of court.
That's a power hungry dude.
Well, that plus, the fact that the Masons had actually were the only ones that signed the Constitution. So basically what we can say is this. Since they're the only ones that signed it, it happens to be their Constitution, they're the only ones that they can hold in contempt. So if you're a member of the Masonic Lodge, you can be held in contempt. If you're not a member of the Masonic Lodge, you have human rights. And if you're being coerced into being a non-voting member of the Masonic Lodge, then that's called human rights violations and pain compliance and torture and all the things we just talked about. Because they can, do their own members that way. It's even that way in their Congress. Their Congress, they can hold their own members in contempt, and that's the only powers they were given. But if you're not a member of Congress, you can't be held in contempt of Congress. Go figure. If that's the case, they tell you right there it's a private membership association. They can only punish their own members, and they can write their own rules right in their own Constitution. And then people come back and say, it's a national government. No, it's not. Because right in your own wording, it states very clearly that they can only punish their own members and write their own rules. Hello? Come on, guys. Okay, every state court has authorized acts against contempts. Acted against contempts, okay. All federal courts except the Supreme Court have equally done so. And with the increasing business in the courts and the not occasional employment of the courtrooms as arenas for political, for well as private legal disputes, and use of this contempt power has caused far-reaching ripples in the pond of social consequence. So if you don't accept, okay, let's go just jump over here just for a second. So this is what they're going to do. If you don't accept that Muslim New Jersey mayor just abolished Christmas to respect other religions, then you're in contempt. See how that can be used?
Right.
They can use it that way.
They throw you away.
It can be, that's exactly how this is being used and how it's going to be used over and over again.
Right, because it's no longer a matter of law; it's now a matter of politics as well.
Exactly. So somehow some king and his courts over here have gotten into politics, which would be, that's a violation of separation of powers. Okay. Keep telling yourselves that because it's all crap. With contempt of court, the rationale for punishing contempt of legislative bodies was a carryover from days of divine and kingly rule. The king could not only do no wrong, he would not tolerate being questioned or impeded, much less flouted or insulted. The attitude of political subservience by individuals to government was inculcated into popular perspectives of state relationships. And as critics of the king were punished and pillared, so were the critics of the courts, original administrators of the king's will. But the parliament was not always in the power of prestigious position it occupies today, nor was it so much a collaborative power of the royalty as were the courts. In fact, Parliament rose as a popular governmental representative body only after years of power struggle in England with the king. And its position in government has, at least periodically, been one of the antagonism toward the king and the kingly powers. American courts and American legal historians have often referred to the history of the English Parliament in support of their theories about contemporary congressional contempt powers. There's no argument. There's no accident there, folks. There's no accident that that Constitution is connected to monarchs. The powers of monarchs in that Constitution. There's no argument there. That's not an accident. They didn't just throw it in there. If those founding fathers were so wise and so worldly and knew so much, obviously they did it on purpose. Are you questioning their wisdom by saying, "Oh, there's no way that could be a part of the of a monarch or some kind of monarch power"? There's no way that could be it because we're a democracy. We just need to get our government back. It's inherent in the wording of the Constitution itself.
Right. So it's an interesting thought because, you know, on the one hand, were they reckless and foolish and they just threw this stuff out there without proper consideration, or in fact, as we've been attempting to demonstrate for a long time now, was it an intentional thing and it's been a rigged system since the very, very beginning?
Are you questioning their wisdom? That they're that smart? I mean, come on. You know, if they were so wise and so genius, like we got a lot of some comments on YouTube, the genius of the Masons is what is it called? Unquestioned and all this other stuff. Okay, well then why did they bring parliamentary and or monarchy powers into it? Well, no, that's not what they did. Yeah, okay, whatever. Yeah, you're like, okay, dude. It says the arguments arise from the historical nature of the Parliament's power. Concedingly, Parliament was once, long ago, a body which discharged both judicial and legislative functions. It was the High Court of Parliament, a body of bishops, lords, knights, and burgesses. There's that burgess again, who exercised the highest functions of the court of judicature, representing in that respect the judicial authority of the king. Now, have you noticed that the courts are using the contempt power to legislate from the bench? Huh. It says another rationale claimed for the exercise of this power by the Congress and the courts as well has been necessity. Oh my, we have to do this. We have got to do this. Okay. The cases often have reasoned that without such a power, the legislative body could not function. The power of the legislature was said to be governed by the same principles as was that of the judiciary. In other cases, this necessity has been labeled self-defense. Without the power to punish contempt, there would be no way to deter disrespect or encourage cooperation. Okay, so there would be no way to deter disrespect and encourage cooperation against violations of your human rights.
Exactly.
So still another ground urged in defense of the exercise of the contempt power has been expedience. We got to get you through here fast, man, because if any evidence comes against us, we got to get you through this thing quick. It's expedience, man. We got to hurry.
Right. Right.
Before any facts come up, we got to hurry.
Exactly. We can't hear that material.
Yeah. Says this is more euphemistic, less than satisfying intellectually, and essentially no more than another way of saying it is necessary. Oh, yeah. This necessity argument has been developed into one of the inherency. All right. The Attorney General argued for the government that the power of court or Congress to punish contempts as a principle of universal law. All of a sudden, universal law comes back in again. Growing out of the natural right of self-defense belonging to all persons, and that the necessity of self-defense is incidental to legislative as to judicial authority. Counsel for Anderson argued that whatever powers akin to contempt which Congress had were applicable to Anderson, who was not an official of Congress. Their argument, huh?
Inapplicable. Or inapplicable to.
Oh, I didn't see the N. I'm sorry. Inapplicable. Freaking glasses. Okay. Their argument was that Article 1, Section 5 of the Constitution gave Congress the power to determine its own rules of procedure within its walls and over its members. This implied that the power to punish is delinquent its delinquent members if necessary. However, the power to punish relates solely to the internal polity and economy of the House, and not to non-members like Anderson, which I think was upheld, by the way.
Mm-hmm.
And if that being said, isn't it inherent in a private membership association that the members vote in their officers of the private membership association?
Yes, it does.
And the officers are allowed to make their own rules and punish their own members. You know, Supreme Court Justice Johnson affirmed the lower federal court's approval of Dunn's defense. His opinion included a philosophical discussion of the power of Congress, of facial erudition, but less than satisfying reason. First, the court reasoned that if Congress had no power to punish Anderson, it had no power to compel his appearance. Because the latter...
Whoa, there you go. There's an admission to that they don't have the power to traffic. Huh. Right there.
Whoops. We don't want that out. See, that's why they have to be expedient, usually.
Exactly. Well, right. I mean, look at traffic court, right? I mean, what is it? You know, you go in there.
Oh my God!
And the guy's just got a gavel, and he just goes, "Yeah, okay, fine, clank, clack, clack."
There's a big problem, folks. If you can hear 300 cases in an hour and a half, all right?
Yeah.
All right. The latter is an initiating process issued in the assertion of the former, punishing power. It followed by agreeing that there was no express congressional power to punish except over its own members. Consequently, if the power existed to punish non-members, it was one to be implied. Oh, okay, so now it's implied. Though the genius and spirit of our institutions are hostile to the exercise of implied powers.
So, you know, we can do it, wink, wink. Let's just keep it, you know, low profile. Because, you know, the integrity...
As long as they can get away with it.
Yeah, the integrity of our institutions needs it. So, although we confess that it's wrong, we intellectually understand that it's wrong. Wink, wink.
That's what I'm saying. They boast the genius and the spirit of their institutions. Okay, so if that's the case, then why did they bring in monarch powers into a constitution that was supposed to be upheld by and for the people? Oh, I'm sorry. Did I question that? Should I be held in contempt now? Leaving the genius and spirit of our institutions, Justice Johnson then verbally embarked upon the social compact theory. Uh-oh, here we go. And wrote that power, properly delegated and responsibly exercised, is for the good of all, as it is for the governmental body exercising that power. With this point made, he skipped to the power of contempt of court, about which he said, courts of justice are universally acknowledged to be vested by their very creation with power to impose silence, respect, and decorum in their presence, and submission to their lawful mandates. Oh, back to slavery again. And as a corollary to this proposition, to preserve themselves and their officers from the approach and insults of pollution. Enforced with this principle, he next switched to and displayed his supreme faith in the ideal of the legislature thusly: that a deliberate assembly clothed with the majesty of the people. Now the people. Okay.
Well, look at that, clothed.
Yeah.
That's an important word there. Yeah.
In charge of with the care of all that is dear to them, composed of the most distinguished citizens, selected and drawn together from every quarter of a great nation. The most distinguished citizens. They didn't say all of them. They just said the most distinguished. That is called the Masonic Lodge right there. whose deliberations are required by public opinion to be conducted under the eye of the public. There's your other one right there. That's the eye of Horus. And whose decisions must be clothed with all that sanctity which unlimited confidence in their wisdom and purity can inspire. Those are your grand masters, wisdom and purity. That such an assembly should not possess the power to suppress rudeness or repel insult is a supposition too wild to be suggested.
It's beyond imagination, man.
Oh my God. All right. The decision continued with the discussion of the fact that the offense by Anderson was committed in the House and was therefore within the express powers of Congress, and that the commitment was limited because the existence of the power that imprisons is indispensable to its continuance. And although the legislative power continues perpetual, the legislative body ceases to exist on the moment of its adjournment or periodical dissolution. Thus, the principle arose that imprisonment for contempt of Congress terminates upon adjournment of that body. Okay, and that case was about a guy that wasn't a member. They kept him for 9 days to compel him to give testimony. And he came back and sued him for it. They kept adjourning. They adjourned each day. And when they did, he was free to go. Well, no, they threw him in jail because they were holding him for contempt. That's what that case was about. It says the powers, and when they get rid of this, they get rid of this T here. It's he powers, meaning and privileges of the House of Commons of England on the subject of punishment for contempt rest on the principles which have no application to other legislative bodies, and certainly can have none to the House of Representatives of the United States, a body which is in no sense a court, which exercises no functions derived from it once having been a part of the highest court of the realm, and those functions, so far as they partake in any degree of that character, are limited to punishing its own members. Okay, so the House of Commons has this power, but because it is representative body and with legislative functions, but by virtue of ancient usage and prescription, because it's prescribed there, they call it prescription, and this is where the word practice comes in, which forms a part of the common law of the land, and according to which the High Court of Parliament before its division and the House of Lords in common sense are invested with many peculiar privileges, that of punishing for contempt being one. All those bodies which possess the power of adjudication upon and punishing in a summary manner contempts of their authority have judicial functions, except only that the House of Commons, whose authority in this respect rests upon ancient usage. That's just another way of saying we're going to use the contempt power. We're going to try you without a trial.
It's just rationalization.
Yeah, they're just rationalizing torture. That's all they're doing. And I don't think there's anything else in here oh, there was one. Okay. Nowadays, the contempt vehicle is more freely used than ever, and in an attitude of retributive punishment, crime subversion, and insecurity are investigated by the legislature, whereas they are not in the English political arena. The number of investigations has greatly multiplied in recent years, and the use of the contempt power in those cases has become more a weapon against individuals than a shield of the government. Individual rights more and more have been subjugated to the passionate political pressures of the moment, with the contempt power being the sword which the legislature more and more seeks and uses. The coin has been turned, yet it looks to history as authority for its new face. It can be fairly concluded that the powers of contempt which are now exercised in the United States originally were adopted from the English common law. the inconsistencies and inappropriatenesses came to a part of the inherited common law package. Though times have changed, as have political climates, the power has remained, in fact, increased. The legislative contempt power has played a lesser role in modern English practice, though the American offspring has grown to proportions considered by some as monstrous. This blind heritage in the hands of power seekers has created a result of kingliness in a government, which is conceived to establish the sovereignty of men. That's basically stating that you have a secret society running your country, and they use contempt powers. In other words, they use pain compliance to get you to do what they want.
I concur.
That's all this is, folks. There's no difference. The kings back then, just because they had they claimed the divine right of kings, didn't make them right.
Yeah, if I could, I'd like to screen share here.
Yeah, go ahead.
Real quick. Here we've got the Law of Nations. And just as a quick little reference, there's a book 1, chapter 4 on the sovereign, his obligation and his rights. And if we read just a few sentences, we don't have to spend a lot of time here, you'll see a dramatic difference in the outlook relative to sovereign entities or individuals. We have said, we're starting here, we have said that the sovereignty is that public authority which commands in a civil society and orders and directs what each citizen is to perform to obtain the end of its institution. This authority originally and essentially belonged to the body of the society. Okay, and that authority is transferred to the sovereign to what? Uphold things that have been determined by the body politic as essential or proper or whatever the case may be. Okay, and that's what a lot of this goes on to say. So the whole thrust of the Law of Nations is that a sovereign is to be a reflection of the will of the people. Any violation of that, can be addressed. Whereas what we just read were arguments counter to that.
Against this, yes.
Counter to that. Rationalization saying, well, we know in principle that, how can we, if the United States was a legitimate government and it's composed of the people and the people reign supreme, then how does some office actually have authority to reprimand one of the people, one of the supreme? It doesn't, it can't.
Or they can't torture them either.
Right, unless of course you do the old wink wink.
Right, now go through this, because this is an awesome way of looking at it, because a lot of people have never really read the Law of Nations. So it says this authority originally essentially belonged to the body of the society to which each member submitted. And that's what you guys think you have, but that's not true. And that was never true since 1789. That's what we're trying to tell you. That was never true. You were told it was that way, but that's not the way it is.
Right.
To which each member submitted and ceded his natural right of conducting himself in everything as he pleased, according to the dictates of his own understanding, and of doing himself justice. But the body of the society does not always retain in its own hands this sovereign authority. It frequently entrusts it to the Senate or to a single person. That Senate or that person is then the sovereign. That is how this works, folks. That's the Law of Nations, but that's not what you have today. If you did, you wouldn't have mayors telling you that they're going to abolish something.
Yeah, I mean, read the very next section, sentence.
That's not recent either. Go ahead.
it is evident that men form a political society and submit to laws solely for their own advantage and safety. If you're not going to protect me as a body of people, if I'm not going to be able to take advantage of that, why would I submit to your belief systems, your outlooks, your behavior patterns, etc.? I'm in it for protection and advantage.
Yes. And that's how the government of the United States of America operates. Right there. It's solely for the own advantage and safety. It's for the advantage of the American nationals and residents and the general postmaster. That's how this government operates.
Right. And we follow it up with this right here. The sovereign authority is then established only for the common good of all citizens, meaning all members, meaning all people that submit or are willing to submit to that body of law that provides for their advantage and safety.
Right. And that's how they become members of that society, is through oath and affirmation. That's how it operates.
Mm-hmm.
It would be absurd to think that it could change its nature on passing into the hands of the Senate or a monarch.
Exactly. There you go. Right there.
That's absurdity.
Thank you.
Flattery, therefore, cannot, without rendering itself equally ridiculous and odious, deny that the sovereign is only established for the safety and advantage of society. Law of Nations is awesome, folks. Yeah. Every time I read it, you become inspired. Every time you see it, it starts making sense.
Mm-hmm. Well, it clears the cobwebs. You know, their system is so distorted and so corrupt, and they spend billions and billions and billions of dollars every year on propaganda via the news, radio, et cetera, the mass media, that, you know, you have to step back and clear your head, because you'll get caught up in the lies and the deceit and the deception. And one other thing that I wanted to mention, you know, the passages that you just read, those folks that are placed into the judicial positions are placed there. They're placed there because they can articulate counter arguments. They can mince words very delicately and produce papers that you think say one thing, but in fact say something else. They're in on it. They know. The people don't.
And this is why we say over and over again, an oath and affirmation is imperative. You have to have that in order to separate yourself from a particular society. In other words, I, through my oath and affirmation, have no allegiance to, in any way, shape, or form, the Masonic Lodge Temple. I am not a part of any of that. I have proof because I have an oath and affirmation, or affirmation. I've got an affirmation is what I've got.
Your papers.
I have my papers, and they are secure. Zero allegiance. If that society falls, it does not affect this government. It does not affect the American National Union, and it does not affect the states of the Union. Other than the real country is now free of willful oppression by a secret society. And I can confidently say that because there have been countless testimonies that, if you scroll back up, please, that 38 and 39 of the Law of Nations are violated not on a daily basis, but a minute-by-minute basis. Every day by this secret society. every single day, every single hour, every single minute of every day. That's how it works. So that being said, we've got some things here we just need some people, if they don't mind looking into. Can you look up the Benjamin Fulford thing? I question some of the stuff he does sometimes. A lot of it doesn't look accurate. Did you see that, Stu? You're muted if you're talking.
I'm sorry. Yep, I was muted, and yes, I was talking, and yes, I have it.
Okay.
One
We
moment.
just need to know if this was a doctored picture or not. We just have a couple other things we wanted to cover.
Yeah. So here's a report that hit the internet a couple days ago, perhaps yesterday, and it's claiming that in addition to the big picture is that apparently there was a lot of arrests in Saudi Arabia late last week, and including princes and things like that, with account freezings. Simultaneously, this report is saying that there was arrests made here within the United States of Clinton and McCain here in particular. They've been placed under house arrest, and the question we have is, can anybody substantiate that these pictures have or have not been doctored? I have a larger picture here. Should be showing up.
It looks like somebody broke their foot. That's what it looks like.
Yeah.
An ankle bracelet actually is just a strap with a little box on it. And it has
right.
a red
So
light on it.
Yep. So the house arrest is they place a GPS ankle bracelet on the individual so that it's not literally a house arrest. It's basically wherever they go, they're being monitored. And this picture allegedly is to show that there's an anklet bracelet, but because we have to save face with these guys and we can't have, all Democratic followers or all establishment Republican followers freaking out that these guys have been placed under house arrest, they show the picture with a covering.
It's being sold. Yeah.
So that's what's being reported. So we're just curious as to whether we've got any folks that can validate whether this is like doctored or whatnot, or substantiate the actual report that there's been some indictments and arrests made.
Although it seems awfully odd that both of them would have the same foot broken at the same time.
Yeah, we're both right foot, etc. Yeah.
Yeah. So just wanted to try to substantiate that. Take a look at it. We've been hearing rumors for the past couple of weeks. I don't know if any of it's true because it's internet.
Mm-hmm.
It's internet. Just like another thing here. Let me share screen. There was another thing that this guy was coming up with a video, and he's claiming that Trump said, "I'm a Mason," in his own words. When I've listened to this video at least 4 or 5 times. And this guy says, this is crazy stupid. He did not say he was a Mason. He said that's actually amazing. And he's right. I agree with what David C. said for life. He says, that actually is amazing. I wouldn't have known that. Okay. And that's where, and then they have the big shift and all that. And the only thing that was odd in this video was, that was somewhat true. And, they're making fun of that. He says he's 33 under the blood. And I believe this guy's talking about Jesus here. And he's not really necessarily talking about Masons. So sometimes, folks, we can go a little bit too far. And the weird thing was how this guy was holding his hands. That's the only thing I saw that was weird. Using the Masonic, we call it the hand signal. Okay, dealing with the what do you call it, the pyramid. So yeah, I can see this part. Okay, but the rest of it, no, it sounds like you saying that's amazing. It's amazing and blah blah blah. However, they do have another one of these videos that's actually a lot more detailed. And you know, if Trump's a Mason and all that, I really don't care. However he wants to do that. I don't know why he holds his hands like that. These are all Masonic signs. Okay. It could be, you know, whatever. He doesn't, I mean, this guy here, he says, what was it? This guy here, he says that he's not a part of the club. He didn't
Newt
go through
Gingrich.
Newt Gingrich. He didn't go through the ceremonies, and he didn't go through the initiation things and everything like that. So Newt Gingrich is telling you that this is a Masonic government, and he's also saying that Trump is not a part of it. I don't know. As of right now, I don't know.
Nor do I. I can appreciate the concern over hand signals, but I've not really been able to find any real credible documentation. And I'm certainly not a research expert, and I don't claim to obsess over this. But I've run 10 minutes here and 20 minutes there, searches to see if I could substantiate whether Trump was part of the Masonic Lodge or not. And I wasn't able to come up with anything as of yet.
Right. Now, this video does show a lot of the hand signals, because hand signals are communications too. Those are hand signals. I mean, it's also a language, and it can be convicting or it can be liberating. You don't know, but you know, Newt is coming out saying that he's not, and all this kind of thing. Either way, the country as a whole, rather than really concentrating on a lot of this, the country as a whole is in, and we're saying this now, is in deep, deep trouble. Deep trouble. This is the first shot across the bow right here. We need to substantiate this. It was sent out 3 days ago. And I don't know how the folks in New Jersey pronounce it. I'm just going to pronounce it Hoboken.
Hoboken.
Hoboken? Okay. Mm-hmm. They pronounce it that way. Just like some people pronounce Okeechobee and Okeechobee. So you just, it is what it is.
Yeah. Hoboken, New Jersey.
And he says he's officially going to take office on November 29th, just in time for Christmas, but the wreaths will not be hung, nor will the carolers be singing with joy. We've done some research on Hoboken, New Jersey, and we're finding that these municipalities are slowly taking over. And we're also finding that these municipalities are private membership associations. So we can honestly say that this individual was not put in office by popular vote of the people. And Hoboken, Hoboken, New Jersey is the city. There's only a certain amount of members there of that city. The rest are just resident aliens. And they don't have any voting powers. So our guess is that this guy that came in, I mean, think about it, okay? In his campaign slogan was, when he was elected, he promised to glorify Allah in every decision. Okay, so we can, knowing the way the people are today in this country, we can say with about 80% accuracy that this guy was put in by the members of the Hoboken, New Jersey, and not necessarily the people. We're finding a lot of that, and that's how they're getting in, and that's how they're getting they're making the cities and turning them into municipalities. So at any rate, those are a couple of things that we have. We are looking into the targeted individuals deal, and we're getting some people. Some of them look credible, some of them don't. What we're looking for are actual X-rays. You're going to claim you're being a targeted individual. A real targeted individual is someone who has chips behind their ears that can be proven. That's what we're looking. That's what we're looking for. If we're looking for, people that are just being harassed or doing this and that, that's different. Okay. Yes, there are human rights violations, but it doesn't qualify as targeted individuals. To put chips in people, that's going beyond right there. That's not a good thing. Okay, so we're really looking for targeted individuals. We will interview you on the t-roh show to share with everybody else your experiences and what you've gone through. But we want to see X-rays. We want to see a real targeted individual. Since we can't come and shake your hand and say hello to you, we just need that evidence so we can say, okay, here it is. And we need to we'd like to verify, because everything that we put on the t-roh show we like to verify the information, so we're not putting out false stuff and fake news and all that kind of thing. So at any rate, thanks for listening to the t-roh show. Do you have anything else, Stu?
No, I'm good. I'm good.
Okay. Thanks for listening to the t-roh show. We do appreciate the likes. We do appreciate the subscriptions. We've been getting a lot of subscribers. Last month there was 139 that came and subscribed to the show. We really do appreciate that, folks. We're not monetizing this. We just like the subscriptions, and we enjoy the fact that people do enjoy the program. They enjoy the program and the subject matter of the program. So thanks very much for listening. We'll see you next week.
Enjoy the work week.